All right. So the lawsuit receipt was quadrant 1. The answer was 2. The pretrial is part 1A of the ABCs of collection defense. Now we're going into 3, discovery. And what I want you to remember, you're going to settle cases here too. And this isn't a weird expression, but you want to go into their underwear. You want to go deep into where they don't want you to go. It's a weird way of putting that, but you were granted the right of discovery, hopefully, by the court when you went to your pretrial. Recall video 1A, part 1A, after the lawsuit, was initiated by the court when you answered. And I told you about the answers and the counterclaim and the counter-affidavit. The counter-affidavit is the most important document of the whole thing. It is the Bible of the ABCs of collection defense. Never forget that. But now we're into discovery. So I want you to listen to me for a second. Imagine you have this great car that your best friend has been eyeing for years. You finally decided to sell it. And you're going to sell it to cash, for cash. He says, I want that car. And you're okay. So you sell that car to him for cash. And the reason he wants it, because he knows you're undervaluing it. And he's going to turn around and sell it. He's also going to ruin the friendship. But he wants that car. That actually happened to me. It doesn't matter. So you sell him the car. You take out the title. You sign on the back of the title to Ed Smith. $2,500, VIN number, all the identification that he will need to show ownership if he sells it or if he registers it. He has to sign it. It's almost like it is a contract, but it's a chain of title. So you bought the car, you're the first time buyer of the car, you sell to him, he gives you the cash, you both have to fill in the information. There has to be an amount so that the state can tax you on that amount. But in order for Ed Smith to register that car, he must have that, let's call it a bill of sale. It's a title to the ownership of the vehicle. So if he wants to register it, he needs the change of title. Or if he wants to sell it, there's boxes on the title if he doesn't get a new title. For the new potential purchaser, he'd be the seller, that would be the buyer. So keep that in mind. I don't give him the chain of title. I don't give him that first title. I don't sign off. I forgot. He goes to register. They go, you can't. You've got to have the title. He goes to try to sell it to Susan. And Susan says, I'll give you $3,500. I can't. That's a deal. He can't because he doesn't have the title. Keep that in mind. All right. So discovery is our best bet to put the screws on to the plaintiff. Debt collector is the plaintiff. You are the defendant. And you are seeking to settle this case or win the case if you filed a counterclaim and you believe they've broken the law, right, either at the state or the federal level. You didn't file that counterclaim unless you had a good reason. Your counterclaim, your answer, your whole case is based on, as we said previously, the counter-aff, the CA. Gave you lots of videos and documents for that. But in discovery, we want to show the court this, that the original creditor did not give the bill of sale, the chain of title, the assignment of the right to do whatever you want to do. You can either sell it to LVNV funding or you can keep it and collect on it. But there's a missing title if I don't give Ed Smith the title. That's your case. You will receive from me videos on how to do discovery, how to do depositions, how to protect yourself against depositions. But the lion's share of all of that. Also, I'll give you a recent video called Assignments and Data Extensions, which all focus on the same thing. You could ask two questions in discovery and your deposition and your request to produce and your request to admit. And those questions would be, show me the assignment from the original creditor, if you want back to my analogy from Parker, to Ed Smith. In 99% of the cases, you can't. We'll put one up on the screen real quick. And Shazam. And that's a bill of sale where a company, Upstart Pass-Through Trust Series 2021, is selling as an initial seller. By the way, it can't be an initial seller. The initial seller was the original creditor. They're just some weird trust that can't get the debt until the originator or the original creditor sells it to them and does their funky securitization thing. And the bill of sale is also saying that Upstart Pass-Through Trust is acting on behalf of additional sellers as servicer. It's all nonsense. But for them to do that, let's say Upstart Pass-Through Trust Series 2021, that's Ed Smith. I am the original creditor, Brian Parker. Who gave this to Upstart Pass-Through Trust for them to sell? There is no reference to that. It's called the bill of sale. It says bill of sale. Or the title, the car title. Where's Brian Parker? Where's the original creditor? That's your discovery. You ask for that assignment when you have a bill of sale. They go nuts when you touch upon that because the attorney's no dummy. He knows it doesn't exist, but usually you can skate right through. They will talk about the bill of sale, and the judge will go, well, he's got a bill of sale. You've got to focus on the original creditor to whoever is in the bill of sale. It's always absent. I'll give you another one. Shazam. In this case, a company called Upgrade is claiming they bought a debt and sold it to UHG. However, and again, what's really cool, they give you the stuff to hang them and they give you tons of rope. So if you read, just take the time to read. For example, we've got this bill of sale up and it says, third paragraph, on September 25th, 2019, each investor referenced will sell, of course, to be sold, a pool of accounts held by such investors described in the account schedule attached to this bill of sale. So investors means more than one. Who gave the stuff to the investors? Who's the Brian Parker or the original creditor that's giving to the investors? And believe it or not, UHG, who is suing my client for the debt, is claiming Upgrade gave them the debt. And here's the bill of sale. But if the bill of sale, if you read again, it says Upgrade represents and warrants that each of the undersigned investors has executed a power of attorney between investor and Upgrade so that Upgrade can then pass it on to UHG. But who gave it to the investors? People skip right over that. But if you just read, you can see in order for the investors to give something to Upgrade, to give it to UHG, who gave it to the investors? And there's more than one. There's each investor. This is their own paperwork screwing themselves. In this case, the weirdness of it is they refuse to tell me who gave it to the investors. They refuse to identify the investors. So they claim that the investors are Upgrade. Well, why does Upgrade need a limited power of attorney between investor and Upgrade, itself and itself? It doesn't. But this is the nonsense that you get. And you do have to push a little. So your discovery should focus on how did the investor get the debt to pass it on. And it's called investor here. It's called Upstate Pass-Through Trust in the previous title. They all have these wacky names. The debt buyer, debt collector, whether it's UHG or in the previous one, Velocity, we own it. So you have to make an issue of those two questions. How did they get it? And where is the assignment that gives the investors the right, or upstate pass-through trust the right? They do not want to address that. It's the key to everything, is the assignment. And then I touched upon how I gave you the video for the extensions. A lot of times they'll say, hey, the sale file, now investor has it and investor's giving it to UHG. But the data extension, so for example, if you wrote me, it would be brianparker@collectionstopper.com. If you wrote brianparker@collectionstopper.net, I wouldn't get it. Their data extensions of the sale file they claim is in the bill of sale representing your debt can be seen easily in the actual file that they're telling the court, here's where Mr. Jones's debt is. But the end, the dot, whatever that is different in the bill of sale, in the sale file. Nobody goes and checks that. You do. If you take the ABCs of collection defense video and ingest all the videos attached to it, there's one data extensions and assignments. Because it's all about the assignments, baby. You've heard me say that many times. There's gonna be a pushback. You should frame your discovery requests knowing there's going to be a pushback. Limit the amount of questions you ask. Have them be hills that you're prepared to die upon. Meaning, when you get before a judge on your motion to compel, judge, this is what I want. It's important. Don't be filing a motion to compel because they didn't give you the third page of a loan agreement. If it's not a signature on that page and it's just terms and conditions that don't apply to your argument, please, that's not a hill to die on. Don't piss off the judge. You want her or him to take you seriously. And the less you have to ask for, be powerful in your request of them. And just keep in mind that you will be doing a motion to compel, which I'm sure I've got a video telling you how to do that. This quadrant 3 is a hill you want to die upon. Cases are won and lost here. And when we get into the big one, the big kahuna, summary disposition box and trial, that's emanating from 3 in that if you win well there, you'll win well there. The case will go away, actually, if you do well there. If they're forced to give you what they obviously don't want to give you, you'll hear these words. Hey, we really need to talk about this case. What are we doing here? Maybe we need to settle this. All right? It's just about pushing. But it's all about your counter affidavit that is telling the court from day one, there's a missing assignment. So that is quadrant or part 3 of the ABCs of collection and defense. Hope this makes sense. I threw in a couple of bill of sales. The importance of discovery to settle this case, to move it along, to even get money back from them. I can't emphasize it enough. I've put lots of videos on this section 3, part 3. So there's tons of stuff, tons of paperwork to make this bad boy happen. You'll do great. Thank you.